Hi, this is Given, and in this video, I will talk about the different kinds of obligation. So we will focus on section 4, joint and solidary obligation period. Okay. So in this video, we will tackle about the kind of obligation according to the number of parties, the joint indivisible obligation. We will also discuss the kinds of solidary obligation according to legal tie. Fourth is the liability of solidary creditor in case of novation, compensation, confusion, or remission. Okay, let's start. According to Article 1207, the concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. According to Article 1208, if from the law or the nature or the wording of the obligations to which the preceding article refers, the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. So, in a joint obligation, each obligor answers only for a part of the whole liability, and to each obligee belongs only a part of the correlative rights. Whereas in solidary or joint and several obligation, the relationship between the active and the passive subjects is so close that each of the former or of the latter may demand the fulfillment of or must comply with the whole obligation. So there are kinds of obligation according to the number of parties. First is the individual obligation. It is one where there is only one obligor or one obligee. And we have the collective obligation. It is one where there are two or more debtors and are two or more creditors. So it may be joint or solidary. Okay? So let us define the joint and solidary obligation. So in joint obligation, it is one where the whole obligation is to be paid or fulfilled proportionately by the different debtors and or is to be demanded proportionately by the different creditors. That this is according to Article 1208. While the solidary obligation, or one where each one of the debtors is bound to render, and or each one of the creditors has a right to demand from any of the debtors entire compliance with the prestation. So this is according to Article 1207. Okay? So how collective obligation presumed to be joined? So number one, for example, if A is liable to B for 9,000, so there can be no problem regarding the termination of the following. A, the person liable to pay; B, the person entitled to demand payment; C, the extent of the liability of the debtor; and the extent of the right of the creditor. Second, where there is a plurality of parties, so it means that there are two or more debtors and or two or more creditors, and the share of each in the obligation is specified. The correlative rights and obligations of the parties are known. Okay. So here, if A, B, and C are liable to D in the amount of 9,000, and it is stated that the corresponding share of each debtor is 3,000, so ibig sabihin 3,000 si A, B, and C. Okay, so we know that A, B, and C are liable only for 3,000 each, and that D is not entitled to collect from each debtor more than his corresponding share in the obligation. So hindi pwede na mag-collect siya na, for example, ay kay A 4,000, kay B 2,000, kay C 2,000 para mapuno yung 9,000. So, hindi pwede siyang ganon. Okay? Okay? So the third is, on other hand, let us suppose that in the same obligation, the share of each debtor or the share of each creditor, if there are two or more creditors, is not specified. So what is the extent of the liability of A, B, and C? In such case, the presumption is that the obligation is joint, and as a consequence, so here are the consequence. There are as many debts as there are debtors. There are as many credits as there are creditors. The debts or and or credits are considered distinct and separate from one another. Each debtor is liable only for a proportionate part of the debt, and each creditor is entitled only to a proportion each part of the credit. Okay. So when is obligation solidarity? Okay, so solidarity liability is not lightly inferred. Under Article 1207, there is solidary liability only when number one, the obligation expressly so states, or second, the law requires solidarity, or the third, the nature of the obligation requires solidarity. Okay, so solidarity liability also exists when it is imposed in a final judgment against several defendants. Okay. So now let's us discuss the kinds of solidarity. So they are according to the parties found. According to the parties found, under of it is the passive solidarity. It is the solidarity on the part of the debtors where any one of them can be made liable for the fulfillment of entire obligation. It is in the nature of a mutual guarantee. And also we have the active solidarity. Solidarity on the part of the creditors where any one of them can demand the fulfillment of the entire obligation. Its essential feature is that of mutual representation among the solidary creditors with powers to exercise the rights of others in the same manner as their rights. Okay? And we have also the mixed solidarity, the solidarity on the part of the debtors and creditors, where each one of the debtors is liable to render, and each one of the creditors has a right to entire entire compliance with the obligation. And second, we have also according to source, under of it is the conventional solidarity, where solidarity is agreed upon by the parties. If nothing is mentioned in the contract relating to solidarity, the obligation is only joint. And we have also the legal solidarity, where solidarity is imposed by the law, and the real solidarity, where solidarity is imposed by the nature of the obligation. Okay. So let us tackle about the joint indivisible obligation. So according to Article 1209, if the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debtor can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. Okay. So here the obligation is joint because the parties are merely proportionately liable. It is indivisible because the object or subject matter is not physically divisible into different parts. So in other words, it's joined as to liabilities of the debtors or rights of the creditors, but indivisible as to compliance. Okay, so this obligation constitutes the middle ground between a joint obligation and a solidary obligation. Okay, so let's have, for example, A, B, and C are jointly liable to give D a car valued at 240,000 pesos. On the date of delivery, A and B are willing to deliver, but C is not. So in this case, D has no cause of action against C for the delivery of the car because as a joint debtor, C is liable only for a proportionate part of the obligation, which is 80,000 pesos. Since the object and the object's car is indivisible, the debt can only be enforced by proceeding against all the debtors for compliance is not possible unless they act together. Okay, so pursuant to Article 224, the liability is converted into one for damages. So A, B, and C will be liable for 80,000 pesos each, or a total of 240,000, which is the value of the car without increase of responsibility for A and B, C. Okay, the unwilling debtor, which is C, shall be liable for damages to B for having violated the obligation. Okay, so what if A and B suffered damages by reason of the non-fulfillment by C? They may recover them from C. Okay, so should any one of the debtors be insolvent, the other shall not be liable for their share. So D must wait until the insolvent debtor can pay. Okay. So second example, if there are two creditors, say D and E, and one debtor, A, the obligation can be performed only by delivering the car to them jointly. So A, so there may be more than one debtor, can insist that both D and E together accept the car, and if either of them refuses to join the other, A may legally refuse to deliver the car. He may deposit the car in court by way of consignation. So the case is if the situation, so here, if the situation becomes liable to pay damages for non-performance, D and E can recover only their respective shares in the indemnity. Neither D nor E may do anything which may be prejudicial to the other, like renouncing or signing the entire obligation without the consent of the other. So this is so because the obligation is joint, the credit of D is separate from that of E. Therefore, neither D or E can act in representation of the other. Okay? So now, according to Article 1210, the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. So it means that they have a differences. So now let's us distinguish the differences between the indivisibility and solidarity. So the differences are indivisibility refers to the prestation, while solidarity refers to the juridical or legal tie that bind ties. Indivisible obligations only the debtor guilty of breach of obligation is liable for damages, while in solidary obligations, all of the debtors are liable for the breach of the obligation committed by a debtor. Third is indivisibility can exist although there is only one debtor and one creditor, while in solidarity there must be at least two debtors or two creditors. And last is in indivisible obligations, the others are not liable in case of insolvency of one debtor, while in solidary obligations the other debtors are proportionately liable. Okay, so the first sentence of Article 1210, let's go back. So here, the first sentence is the indivisibility of an obligation does not necessarily give rise to solidarity. Solidarity. So it simply means that liability in an indivisible obligation may be either joint or solidary. Okay. So the second sentence, nor does solidarity or of itself imply indivisibility. Okay. So it just simply means that the subject matter may be divisible or indivisible. Okay. Okay, so there are kinds of solidary obligation according to the legal type. So according to Article 1211, solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. So they are uniform when the parties are bound by the same stipulations, or non-uniform or varied when the parties are not subject to the same stipulations. Okay? So solidarity not affected by diverse stipulations. The essence of solidarity consists in the right of each creditor to enforce the rights of all and the liability of each debtor to answer for the liabilities to all. Therefore, there may be a solidary obligation although the parties may not be bound in the same manner and by the same periods and conditions. So the rule is that the creditor may bring his action in toto against any of the solidary debtors less the shares of the other debtors with unexpired terms or unfilled conditions who are entitled to defense under Article 1222. Okay? So, the meaning of toto, so when we say toto, it is a Latin phrase that means in all or completely. So, it means upon the expiration of the term or the fulfillment of the condition, the creditor will have the right to demand the payment of the remainder. However, the parties may stipulate that any solidary debtor already bound may be made liable for the entire obligation. So, an act of solidarity creditors is for prejudicial to others. So, that okay, so a solidary creditor may do any act beneficial or useful to the others, but he cannot perform any act prejudicial to them. If he performs such an act and as a result the obligation is extinguished, he shall be responsible to the others for damages. As far as the debtor or debtors are concerned, the act shall be valid and binding. So the rule is based on the theory of mutual agency. Okay, so that is right of one to act for and in the name of the others among the solidary creditors. So there are assignment by solidary creditor of his right. Okay, so in case of it, in the absence of consent given by the others, a solidary creditor cannot assign his rights to a third person. The reason behind this prohibition is that each creditor represents the other, and the assignee may not have the confidence of the original solidary creditors, considering that the assignee, after receiving payment, may not give the shares of the others. If the assignment is made to a co-creditor, the consent of the other creditors is not necessary. Okay? So according to Article 121(3), solidary creditor cannot assign his right without the consent of the others. Okay, so there is a rule to the payment to any of the solidary creditors. So according to Article 1214, the debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Okay, so the rule is that the debtor may pay any one of the solidary creditors, but when a demand, judicial or extrajudicial, has been made by one of them, to avoid confusion as well as prejudice to the more diligent creditor, payment should be made to him. Otherwise, the obligation will not be extinguished except insofar so the creditor pays share is concerned in case the latter does not give to the other creditors their shares in the payments. So Article 1214 is applicable not only in cases of active solidarity but also where the solidarity is mixed, although the singular debtor is employed in case of mixed solidarity. So the debtor upon whom no demand has been made may pay any one of the solidary creditors. Okay? So before we proceed here, I will give you an example in this payment to any of the solidary creditors. So, for example, A is liable to pay B and C solidary creditors 10,000. So, in this case, A may pay either B or C. But if a demand, judicial or extrajudicial, is made by B, payment should be made to B. If A nevertheless paid C 10,000 pesos, B is still entitled to his share from A in case C does not turn over to B the latter's share. If B and C demanded payment at the same time, A may pay either of them. If there are two or more debtors, only the debtor upon whom demand had been made is bound to make payment to the creditor who made the demand. Okay? So the liability of solidary creditor in case of novation, compensation, confusion, or remission. Okay, so novation, you can see it in Article 1291, the compensation, Article 1278, confusion, Article 1275, and remission, Article 1270, are modes or causes of extinguishment of obligation. So Article 1231. It is but logical that the creditor who executed any of these acts should be liable to the others for their corresponding shares, considering that such acts are prejudicial to them, according to Article 1212. So, A debtor and B, C, D solidary creditors in the amount of 30,000 pesos. If B validly condones the debt in the amount of 18,000 pesos, he shall be liable for 6,000 pesos each, C and D. If B collects 15,000 from A, B must account for the 5,000 share each of C and D. Okay? So as to effect of novation, etc., where obligation is joint, in a joint obligation, novation, compensation, confusion, remission, prescription, and any other causes of modification or extinction does not extinguish or modify the obligation except with respect to the creditor or debtor affected without extending its operation to any other part of the debt or of the credit. Okay. So here, for example, if the obligation of A in the above example is joint, the condonation will affect only the share of D in the amount of 10,000 pesos. So, A is still indebted to C and D in the amount of 20,000 pesos. Okay. So in the previous first example, only 12,000 of the debt remains. The obligation of A to pay the 18,000 condoned having been extinguished. Okay. So here's the right of a creditor to proceed against any solidary debtor. So according to Article 1216, the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the other, so long as the debt has not been fully collected. So here the choice is left to solidary creditor to determine against whom he will enforce collection. Okay? So the effects of payment by a solidary debtor. According to Article 1217, payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. So when one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtors paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. So here are the effects of payment by a solidary debtor. Okay, so number one, between the solidary debtors and creditors. So here, payment made by one of the solidary debtors extinguishes the obligations. When speaking of payment that extinguishes an obligation, the law refers to payment in full. Okay, so however, the creditor for his protection is given the right to choose which one to accept if two or more solidary debtors offer to pay. So second, among the solidary debtors. So after payment of the debt, the paying solidary debtor can demand reimbursement from his co-debtors for their proportionate shares with legal interest only from the time of payment. So the other debtors do not become, by virtue of such payment, solidary debtors of the debtor payer. Their liability is not based on the original obligation which has been extinguished, but upon the payment made by the co-debtor, which creates a joint obligation of reimbursement on the part of the others. However, in case of insolvency of any of the solidary debtors, the others assume the share of the insolvent one pro rata. Okay? So the third one is among the solidary creditors. The receiving creditor is jointly liable to the others for their corresponding shares. Okay? So, for example, A, B, and C are jointly and severally liable to D and E in the amount of 3,000 pesos due on, for example, in June 5. So, if both A and B are offered to pay T on on uh, June 5, so the latter may choose which one to accept. Okay, if A pays the entire amount of 3,000 on June 5, the obligation is extinguished. Now let's move on to the effects of payment after obligation has prescribed or become illegal. So according to Article 1218, payment by a solidary debtor shall not entitle him to a reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. So when a solidary debtor pays the obligation, he is entitled as a rule to reimbursement from his co-debtors. Article 1218 mentions two cases when the paying debtors cannot get any reimbursement. So when the obligation has already prescribed or become illegal, the obligation is extinguished. Hence, there is no more obligation to be complied with. Okay? So for example, if A and B are solidarily indebted to C in the amount of 1,000 pesos, so the debt is prescribed. If A nevertheless paid the debt, he cannot collect from B the share corresponding to the latter. Neither can A recover from C when a right to sue upon a civil obligation is lapsed by extinctive prescription. The obliger cannot recover what he has delivered or the value of the services he has rendered. Okay? So another example, A and B are solidary bound to deliver 10 carabaos to C for slaughter purposes. So later, the lawmaking body passed law which prohibits the slaughter of carabaos. If A nevertheless delivered the carabaos knowing that the slaughter of carabaos is already prohibited by the law, he cannot get any reimbursement from B because the payment was made after the obligation had become illegal. So we have the prescribed periods of action. So by prescription, one acquires ownership and the other rights through the lapse of time in the manner and under the conditions laid down by law. So in the same way, rights and actions are lost by prescription. Okay. So the following action must be brought within 10 years from the time the right of action occurs. Number one, upon a written contract. Second, upon an obligation created by law. Third, upon a judgment. Okay. And the following action must be commenced within 6 years. So number one, upon an oral contract. Second, upon a quasi contract. And the following actions must be instituted within 4 years upon an injury to the rights of the plaintiff upon a quasi-valid. Okay, so the statute of limitations, however, may be superseded or modified by a contract between the parties. Okay, so these are the effects of remission of share after repayment. So according to Article 1219, the remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors in case the debt had been totally paid by any one of them before the remission was effected. Okay, so here are the effects of remission of share after repayment. Okay, so number one, if payment is made first, the remission or waiver is of no effect. Second, there is no more obligation to remit if remission is made previous to the payment and payment is made. Solution indemnity arises. It is third, it is incumbent upon the debtor whose debt is remitted to prove the priority of the remission to the payment to release him from responsibility towards his co-debtors. Okay? So, according to Article 1220, the remission of the whole obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. Okay, so there's no right to reimbursement in case or remission. And that is included in Article 1220. Okay. So the reason for this article is that the debtor who obtains remission pays nothing to the creditor. Remission is essentially gratuitous. It is really a donation. So observe that the articles applies only when the whole obligation is remitted. In case of novation, compensation, or confusion, the debtor with whom it is affected is entitled to recover from his co-debtors their corresponding shares of the obligations. Okay? So next one, the rules in case the thing has been lost or prestation has become impossible. So number one, the loss is without fault and before delay. Second, loss is due to fault on the part of solidary debtor. Third, loss is without fault but after delay. Okay. So here are defense available to a solidary debtor. According to Article 1222, a solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. Okay? In actions filed by the creditor, a solidary debtor may avail himself of the following defenses. Number one, defenses derived from the nature of the obligation. Second, defenses personal to or which pertain to share of debtor's suit. Third, defenses personal to the other solidary debtors. Okay? Okay? So thank you for listening.